Thank you so much for that kind introduction, Ursula. It is such a pleasure to be here for this lecture series, and it is a really innovative initiative from your side to put together such an cross-disciplinary set of scholars. This is something that is really unique, and I hope that in the future we will look back and say that that was the first time, so that this is something that we can continue doing. So I will just share my slides there. I am very honored and happy to have this opportunity to speak to you all about sustainability and law in the Anthropocene. As Ursula explained, my background is from the Faculty of Law. I'm a law professor, and I have been doing research in the area of company law, corporate governance, and sustainability for over a decade now. And my work has become increasingly interdisciplinary, which has been, from my perspective, something that has been necessary to do, because I have found increasingly that it is very difficult to have any understanding of the role of law in contributing to sustainability if I don't really understand what sustainability is or what it can be, and how law can affect, for example, market actors, including business, which is my area of research. So I've had the pleasure through over the last 10 years, especially 2 international research projects, the Sustainable Companies Project, and later the Sustainable Market Actors Project, the SMART project, to work together with a very large international group of scholars from many different countries and increasingly from different disciplines. So this has very much enriched my approach, and what I will speak about today reflects the joint teamwork in these projects more than it does only my own research. So with that starting point, I will give a quick overview of my presentation, and I will start with saying something about what I mean when I speak about sustainability, because sustainability is one of the most abused concepts in the world, and it seems that anybody can say that they have a sustainable company or a sustainable investment or a sustainable product, and often when we look at it from a strict research point of view, there is very little sustainability in that. So I think it is important, whoever speaks about sustainability, that they clarify what they mean, and that is what I will do first of all. And then, having set the stage in that sense, I will then turn to the significance of law, because law has great potential for bringing us towards sustainability. But unfortunately, before we all get very excited about this potential, I must say that I thereafter will turn to the failure of law, because law has not been able to realize its potential so far. But I don't think that we should give up. I do think there is potential in law that still can be realized, and I will turn, after describing the failures, the limitation, to the possibilities in law as I see it. And I will, of course, only be able to give you some snapshots of that in one lecture, but I will take you on a journey from the international level of law through EU law and down to the example of Norwegian law as a national example of law. And that doesn't mean that this is especially relevant or important to speak about in the European or the Norwegian context. It is as important in any part of the world. And if my expertise had been located in a different part of the world, I would have spoken about the initiative of the African Union and their Agenda 2063, and then maybe South Africa as the national example. But I will take you through my journey that I can share with you within the limited time of the presentation, to give you an overview of what I see as the possibilities in law and the limitations as it is. having done that, I will then conclude with some reflections on how law needs to develop if it truly is going to be law for sustainability. So starting then with what I mean when I speak about sustainability. Often people think about climate change when they talk about, think about the grand challenges of our time and what really needs to be dealt with if we are going to have any hope for a sustainable future. And of course, climate change is an extreme challenge that needs to be dealt with. It is a threat to the possibilities for securing a sustainable future for us, and ultimately it can even be an existential threat to humanity. So it is crucial to deal with climate change, but climate change is not the grand challenge of our time. It is just a part of it. So to explain more what I mean with that, I will turn to a concept that I know you have been introduced to earlier in this lecture series. For example, if you listen to Dag Hessen's presentation, but I will say a little bit about it nevertheless to set the scene for going deeper into the role of law. So the planetary boundaries concept was first developed under the leadership of Professor Johan Rockström at Stockholm Resilience Center, and a large group of natural scientists from different countries and from various fields of natural science. And their aim was to identify what we all, if we think about it, intuitively understand, that there must be some limits to what we can take out of nature and what we can dump back into nature and still expect this one planet that we are living on to be a safe space for humanity. And in this first seminal article by Rockström and his co-authors in 2009, the title was Planetary Boundaries, a Safe Operating Space for Humanity. And as the case is and should be, when there is new groundbreaking work in academia, there has been a lot of criticism and discussion and further developments of various elements of this. And one of the other seminal papers that this figure that I share here is based on is the work by Professor Will Steffen and his long list of co-authors in 2015. And what this figure illustrates is that in 2015, the state of the art in the area of planetary boundaries was that we have currently transgressed or at the grave risk of transgressing at least 4 of the currently identified 9 planetary boundaries. So that illustrates, and the reason that I use some variant of this figure practically whatever I'm talking about, even when I give lectures on Norwegian company law for my master students, at some point in the introduction, I start out with this planetary boundaries figure because it brings home, or has the potential of bringing home, that there actually are limits, that being environmentally friendly or being perceived as environmentally friendly or being greener than a competitor, for example, in business, that is not enough. What is enough is bringing the production and consumption in the world, bringing our economies and societies within planetary boundaries. There are limits, and nature doesn't care about what kind of colorful goals nations or businesses or investors might have. Nature only cares about what we do and don't do, and not at all about what we say that we aim to do. And also, the planetary boundaries concept illustrates that it's not just about climate change. Another core boundary, as it is called, which means that transgressing that boundary in itself may be enough to bring the Earth out of its relatively stable state, the Holocene that it has been in for the last 11,000 years or so, is biodiversity. So biodiversity is coming up on the radar of public discourse now, but for far too long, it has been something that has not been mentioned in the same context as climate change. And then there are also other planetary boundaries that have an equally strong potential for very destructive impacts. And the third one that I want to mention in that context is one that is not yet quantified and therefore, of course, risks being ignored. And that is what the planetary boundary scientists call novel entities. So that means that stuff that we put into nature that doesn't naturally belong there, with microplastics, which has also come up on the radar recently, and nanomaterials and various forms of chemical pollution being examples there. It's not yet quantified, so we don't know how far we already have gone, but there is a little reason to believe that we are deep into the green on novel entities. And these are, of course, all interconnected and impact on each other. So increasing climate change impacts on biodiversity and vice versa. And talking about planetary boundaries doesn't mean that we are only interested in the global impacts. These global, the transgression of the boundaries on global level is the result of everything from, for example, greenhouse gas emissions that have the same impact wherever they come from in the world, and really localized impacts like the use of fresh water or land system change, which has various impacts depending on where it happens. So this is a very complex area of science with interaction and various feedback loops between local and global levels. And that is the framework, the outer framework for how we have worked with sustainability in the SMART project that I mentioned briefly in the beginning, which was an EU-funded project where also Stockholm Resilience Center was one of the partners. And yet, staying within planetary boundaries or getting back within planetary boundaries and staying there isn't even the grand challenge of our time. Because as Kate Raworth has illustrated, by taking the planetary boundaries figure and placing the social goals of the UN Sustainable Development Goals within that figure, it's not just about staying within planetary boundaries, it's also about securing social foundations for humanity now and for the future. That is the grand challenge of our time, which is, of course, extremely difficult to achieve when we already are transgressing planetary boundaries, and at the same time we are very, very far away from securing social foundations for humanity now. Although some progress is made in some areas, we know that there is rising inequality in and between countries, and we have still the very unnecessary and still so pervasive issue of thousands and thousands of people dying every day for poverty-related reasons. So Kate Raworth took the social goals of the UN Sustainable Development Goals as a starting point, which means that this is an area that requires more research, which Kate Raworth and others, including Rockström, as you can see from the reference, have contributed to, and which we also have worked on in our research group together with colleagues from Stockholm Resilience Center. The interconnections of the various elements of sustainability or unsustainability as the path that we are on now are very strongly illustrated by the pandemic that we are currently all under, which is the reason that I'm sitting at home and presenting this instead of being in one of the wonderful lecture halls of the University of Oslo. And so what does this mean then for the different countries of the world? Many might think that, well, Norway is a sustainability champion, right? I mean, we all know how green and environmentally friendly and amazing Norway is. I mean, after all, it was Gro Harlem Brundtland, the first female prime minister in Norway, who also led the work with the UN Commission, our common future, who coined the phrase of sustainable development. But if we look at recent research by Jason Hickel, who has developed the Sustainable Development Index, we see that Norway is actually among the worst countries in the world. And that result is achieved when one actually looks at what countries do and the interconnection between what one country does and the rest of the world. Based on this, we can see that there is no country in the world that is sustainable. And talking about developed and developing countries is a misnomer. In Jason Hickel's terminology, we are all developing countries. Either countries have achieved quite a lot when it comes to securing social foundations for their population, like Norway has, good welfare system, at least for parts of the population, or it hasn't done that and hasn't put so much pressure on planetary boundaries. But there's no country in the world that has achieved both. So we're all developing countries. There's no basis for one country or one part of the world trying to tell the rest of the world what they should do to come up to our level. Rather, we should all find out how we can move together towards a more sustainable level. So with that starting point, with that backdrop, I then move to the significance of law. Now, law is amongst society's most powerful tools. It has a great potential to set objectives in a way that are not just political language, but that actually give us rights and give duties to government or other actors in society. It's generally, law's role is to set out rights and duties for the various actors in society, and it can have a role to distribute wealth so that we secure social foundations for more people, and it can enforce rights and repair wrongs. So that's all very good. And from a more theoretical perspective, we can say then that law has a constitutive role. It sets out what is, for example, what is property, who has a right to own property, what does it mean to own property, what does it mean to be a company or to be a shareholder in a company, what does it mean to be operating in a financial market or a product market. All of this is based on legal norms. And law also contributes to the way we understand things by conceptualizing, for example, property and companies and environment and people and human rights. All of this is conceptualized to some degree or other through law. And we don't always think about how strongly we're influenced by what law sets out as what is the way that we should understand various concepts and actors and rights and duties. Law also has a powerful potential to change norms. So norms as broader than obviously than legal norms. So norms as in the way that we act, the way that we think we should act, the way that we think others should act. There's the smoking ban, or the ban in smoking in restaurants is one good example of how law can change norms, which Dag Hessen also mentioned. So potentially, if we had good law and it was enforced, we could make giant steps towards a sustainable future. But instead, as I indicated in my overview of the presentation, I must speak about the failure of law. And a very inspiring, although the message is basically a bit depressing, volume in this field is Capra and Matei's The Ecology of Law, where they do a very interesting comparison of the development of natural science and the development of law. And they show how natural science has moved from a very mechanistic view of the world to seeing that everything is connected with everything else, and that to truly be able to understand anything at all in the world from a natural science perspective, we need to take a systems-based perspective and understand the interconnections within the various ecologies. And this has also been taken further in sustainability science, where they speak about social ecological systems, understanding the interaction between society and nature, humans and various elements of nature, and how all this is interconnected. But what law has developed, as Capra and Mattei show, is not in the same direction as natural science has. It has remained on a very mechanistic path, which gives a very siloed approach, understanding society as fixed elements that can be regulated or not, as the case may be, but not seeing the interactions of these at all. And as they point out in their book, while much of the discussion in policy is often about whether the state should be a market actor, or whether there should be more property on private hands. But they say that, and make a very convincing argument, that the main distinction isn't between societies that think the state should have a strong role or that private actors should have a strong role, because it's all about property and power, whatever hands property is on. And that we should rather move away from property and power towards an understanding based on commons and community, where they of course also draw on Elinor Ostrom's work. And indeed, as a law professor, I can also confirm that after over a decade of analysis of law, I can say that law tends to be rigid, backward looking. And this is unfortunately not only what the law is like. Often lawyers, including legal scholars, are like this. If you ask a legal scholar, is it possible to go to the courts and claim that protection that the Constitution gives us, then they will look backwards and say, what does case law say? And if case law doesn't say anything, then they will say no. It seems to be more a policy formulation. Also, and even more importantly, law tends to be a path-dependent perpetuation of inequality. So while we may tend to think of law as value neutral, law never is. And law is always the result at any time of power struggles in society. So what we see today as what the law tells us, with the influence that law has through the conceptualizations of who has a voice, for example, in companies, that influences what we think is possible to do and keeps a lot of the world on a very unequal and unsustainable path. And there is also an inverted relationship between what law is able to do and what needs to be done. Because the strongest basis for powerful regulation and enforcement of law is usually on the level of the nation states. But sustainability is not a national issue. Sustainability is a global issue. And again, referring to the area that I work on with business, which is a driver of unsustainability and also has enormous potential for being a part of the solution, business is also international. Although companies are creatures of national law, as the Court of Justice has said, business doesn't operate within national borders. So with that depressive message about the failure of law, one may wonder then, which is how I read, maybe they didn't mean it like that, but I read Capra and Mattei as saying that we need to reinvent the whole legal system, to get a legal system, as the subtitle indicates, which is in tune with nature and community. And I remember when I read that and came to the conclusion, then I thought, well, actually, it's not as bad as all that. I do see possibilities in law as it is today. And I see my role as a law professor in identifying those possibilities and also identifying ways that we can operationalize those. So let's have a look at those possibilities, starting from the level of international law. When it comes to planetary boundaries, we have a whole range of international conventions on that has been created by the international community that promote various aspects of the planetary boundaries. And the recognition of the ecological limits of our planet are reflected in varying degrees in this environmental body of law. And the most prominent part of this body of international law that most have heard about in some context or other is the climate change regime, which has concluded so far with the Paris Agreement in 2015. So we have a lot of law on the international level, but unfortunately, these international environmental regimes, including the Paris Agreement, are in themselves insufficient to ensure that we come within and stay within the planetary boundaries. The exception seems to be, excuse me, stratospheric ozone depletion, where the follow-up of the Montreal Protocol actually has gone a long way towards resolving the problem. When it comes to social foundations, we also have a very good basis in international law. The human rights as set out already in the Universal Declaration of Human Rights of 1948 include the right to life and thereby to sufficient water, food and medicine, the right not to be held in slavery, the right to equality and not to be discriminated against, the right to work and just and favorable conditions of work, including remuneration, ensuring for workers and their families an existence worthy of human dignity. That's quite amazing that they wrote that in 1948 and managed to agree on that. And of course, there is a large body of human rights regulation on the international level that goes deeper into various aspects of this, and where the elimination of discrimination is crucial. But not only that, and while we in Europe have tended to focus on civil and political rights when it comes to human rights, in a global perspective, as I indicated, excuse me, as I indicated also with the quotes from the Declaration of 1948, fundamental human rights are inextricably connected to a viable environment. The right not only to life, but to the basics needed to be able to live. And it's not just about this. The planetary boundaries I've touched upon, social foundation, human rights, fundamental labor rights, and so on are important, are crucial to achieving the aims that we want to achieve a sustainable future. But to do this, we also need to secure the economic basis for domestic welfare states. And there is also a body of legislation on the international level in that area concerning, for example, anti-corruption and taxation. So there is a lot of law on the international level that speaks the language that resonates with the sustainability goals. But international law tends, not surprisingly, to consist mainly of compromise texts, where there is more emphasis on objectives and less on clear rules and implementation. So international law has to rely heavily on regional and national law to be able to follow up these elements. And as regards business, for example, that is my area of research, international law doesn't regulate business directly. It regulates domestic states, nation states, who then in turn should regulate business to achieve these goals. But unfortunately, always do so, to put it mildly. But my approach to law isn't limited to hardcore law, as with these conventions and treaties that I have mentioned. It's also important when we look at the fragmented but still emerging framework of law for sustainability on the international level, that we also include what we can call more soft law, or bodies of norms that reflect international policy goals, or that have other sources. And to illustrate that, we can turn here first in, again, speaking about business, the OECD guidelines of 1976. So in 1976, the OECD agreed on guidelines for multinational enterprises, which are, as a matter of their language, quite good. Unfortunately, there has been very little connection until very recently, between the OECD principles for corporate governance, which have been seen as, until again recently, much more important for how business should be governed, which shows again the silo thinking also on the international level. But these guidelines have been developed and strengthened over the years. 2011 is the year for the latest version. And in 2011, the United Nations also sanctioned the guiding principles for business and human rights, which were developed under the leadership of Professor John Ruggie as a response to the failure of agreeing on UN norms for business and legal norms for business and human rights. So they developed these principles, and as you will hear as I move further into the lecture, they have been quite important for the development further also on the EU level of legal norms. So we see here also these interactions that we can have between various bodies of soft law and the levels of law from the international level through the regional and down to the national. The UN Sustainable Development Goals, the SDGs, which were adopted in 2015, have given a great impetus to the debate on how to achieve a sustainable future, and are very important, together with the Paris Agreement on climate change, in that sense. But they are not a sufficient framework for achieving sustainability, achieving a sustainable future. There is no firm framework within which to understand the SDGs in the way that they are presented. They are a linear list of goals. There is no mention of planetary boundaries. They mention all good things, but they don't say what depends on what. And they, for example, promote economic growth without any limitations for all countries at all times. They also include some human rights in the language of political goals, which could actually undermine their position, and they don't sufficiently include indigenous people's rights. So here again is the importance of seeing the connection between a research-based concept of sustainability, what it actually means, and analyzing the whole legal framework for sustainability in that connection. So going from that then to the EU level, sustainability actually has a really strong basis in the EU treaties. It is included amongst the overarching objectives for the European Union internally in Europe, and also which was groundbreaking when it was adopted in the Lisbon Treaty. How many years ago was that? 15 years ago, maybe? To also regard EU's role as a global actor. So this is just one element that I've included here to illustrate this, where the treaties say that the EU shall contribute to peace, security, the sustainable development of the earth, solidarity and mutual respect among peoples, and so on and so on. So this is a very good basis, which as a matter of EU law is actually really important, because EU law is a very objective oriented area of law. So that means, at least as a theoretical starting point, that any area of law whatever its specific legislative objective would be, it is meant also to contribute to the achievement of the overarching objectives of the EU. And the EU to follow up, the EU treaties to follow up on that also has several what we call horizontal integration principles. So the one that I will share with you here is the one in Article 11 in the Treaty of the Functioning of the European Union. And as I see it, it is a codification of the core of the principle of sustainable development, which many authors, including Christina Vogt, argue is recognized as a international principle of international law. So the treaty here sets out clearly that environmental protection requirements must be integrated. So environmental protection requirements must be integrated into all areas of EU law and policy with a view to promoting sustainable development. Now, of course, if that had been followed up in practice, then Europe and the world would have looked quite different, but it gives a basis. And it's not the only one, although it is the one that is formulated the most strongly. We also have a similar one for social policies, and we have general policy coherence provisions, which strengthen what I said as a legal scholar, that the EU law system is meant to be an objective-oriented system that together, in all its various aspects, promotes the overarching objectives. But unfortunately, although the Court of Justice of the European Union has done quite a lot to promote these objectives, in some cases the opposite, as unfortunately the case can be with courts. They can be sustainability champions or they can be barriers. But as a general judgment, I think one can safely say, unfortunately, that the EU is still geared towards economic growth as an overarching objective, in contradiction to what its treaties say. But things are happening, and never has there been such an exciting time to be an EU law scholar as now, because sustainability is very strongly on the European Union agenda, and it has become increasingly so over the last decade. In my area of research, I can pinpoint that starting point 2000 to 2011, so it's exactly a decade. And with the Commission that we have now, and its European Green Deal, and with its ambition of leaving no one behind, it's really exciting. And there are a number of initiatives that go in the right direction. But unfortunately, although the EU recognizes the limits of the planet in their own environmental framework programs based on planetary boundary science, there is still a tendency towards silo thinking also in the EU, too much emphasis on climate change. And I'm saying that not because climate change isn't very important, but it's if we think that we can mitigate climate change first and then turn to the other problems, then we probably won't achieve the climate change goals, climate mitigation goals, and B, we definitely won't be heading towards a sustainable future. But these are very, very exciting initiatives that are happening. And it was therefore also especially exciting to coordinate the SMART project in this phase. So we applied for the funding for the SMART project in 2015. And the development from 2015 and until we concluded the project last year, just before the pandemic hit us, was really amazing. So we had to work hard to follow up with the new initiatives from the EU and analyze those in the context of our research-based concept to sustainability. And instead of having to start from scratch in many cases, we could instead say, for example, the Sustainable Finance Initiative is a really, really good step, but we need it needs to be strengthened and broadened to really contribute to sustainability. So that is what we did over the last months of the SMART project, that we developed a set of reform proposals with the aim of strengthening the potential of European law and policy to contribute to sustainability. And we continue working on these in projects that we have now with the smart legacy plans. And then we can turn to the case of Norway. Unfortunately, sustainability in Norwegian law is best categorized as a missed opportunity. It could have been so different, because Norway once upon a time was a really a rising star and a country that other countries look to for how they could be sustainable. And in 2014, the Norwegian constitution was revised, and it sets out very clearly in its human rights chapter, fittingly, our right to a viable environment for us and for future generations. But although the Norwegian Supreme Court in some cases has been really an environmental champion, in the most important lawsuit of our time, the Norwegian Supreme Court failed miserably, and instead proved to be rather a guardian of the hypocrisy of the Norwegian government and its aim at securing sustainability while continuing to pump up oil. There is a lot more that I can say about this, and we can return to it in the discussion if anybody has any questions about it. I just want to mention one more thing before I move on about the role of Norway. Norway is a very small country, which Norwegian policymakers often will refer to if somebody asks them to actually do anything when it comes to sustainability in the world. But Norway is also the home of one of the largest financial actors, namely the Norwegian government pension fund Global, which we colloquially in Norway refer to as the oil fund. And the regulation of that is, of course, crucial. And there we see indications of a recognition of the importance of sustainability in the mandate, in the legal mandate for the fund. And the managers of the fund are doing some good things, but it's not enough. And here we can connect also to the OECD guidelines, because the OECD guidelines have a system with national contact points, which are not courts, but which are mediators, where somebody who has a complaint against the company because they are not following the guidelines can go there, and then the contact point will try to find a solution between the parties. And if not, they will come with a statement. And in the POSCO case from 2013, the oil fund was the aim of a complaint for the Norwegian national contact point. And the fund managers in the Central Bank of Norway, they refused even to meet and talk about this, because they felt that they, as a small investor, which they are in around 9,000 companies around the world, don't have a role to play. And there we actually saw a development where that case instigated a change in the OECD, not in the direction that the Norwegian government tried to get, namely to exclude investors from the scope of the guidelines, but rather to clarify what the responsibility of investors are. Of course, this is not hardcore law, but it's important. And the OECD guidelines, together with the UNGPs, the UN Guiding Principles for Business and Human Rights, have contributed to some of the very exciting developments that we now have in the EU, which will also influence Norway, whether the Norwegian government wants it or not. So after those few snapshots of what the state is when it comes to law and sustainability, I will conclude with a few bullet points on what I think is important to develop law to actually be something that secures a sustainable future for us. The first starting point is that law for sustainability has to be about what is often referred to as strong sustainability, but which more accurately could be called real sustainability. So which excludes the possibility of destroying nature but doing something really good in another area of policy and calling that sustainable. It also means that we have to have an objective-oriented approach. So we have to reform the direction of many areas of law towards the objectives of sustainability. And it has to be situated within planetary boundaries. So with reference to the work notably of our postdoctoral scholar, Eleanor Maitre-Eken, we have to move towards sustainable circularity. So circular economy is not good enough if it's not a sustainable one, which also means that we have to move from trying to do things in a more efficient way to towards sufficiency. So we have to reduce, for most of us, we have to reduce production and consumption to stay within planetary boundaries and do that in a way that secures social justice for everybody. We also have to strengthen the legal principle of precaution. And we have to ensure that all of this is done in a way that secures social justice for current and future generations at the same time. So that means securing inclusion and participation also of those who have been totally ignored in many areas of law and policy, such as invisible workers in global value chains, or indigenous communities that are affected by the business that is done across such value chains. And finally, it has to be a law, every element of law has to be a part of a larger coherent set of legal rules and principles and enforcement that brings us policy coherence for sustainability. The integration rules that I mentioned on the EU level are good examples of how this could be done, but it needs to be done across all levels and actually be followed up. And this also means embracing complexity and uncertainty, because there are no final answers. It all has to be a part of a continuous work in progress improvement process, but which mustn't devolve into incremental improvements. It has to be enough to achieve the objective, and it has to be evidence-based. So we have to always control what we are doing in law against what kind of impact law has, and we have to see it in context. So I'll conclude with this picture from ongoing research that we started with in SMART, where we see law as just one way of regulating what business is doing and see the interaction between legal norms and social norms, the impact of markets, and what we call architecture, which is a bit cryptic, but I'll be happy to return to that in the questions if anybody would like to hear more on that. This list of possible future further reading is not an obligatory list. It's just for those who might be interested can look into it. But for those students who are following this, feel free to ignore most of this on the list, except for the one that is in your reading list. I look forward to your questions, and I thank you very much for your attention.